Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Hello and welcome back to the Estate Blueprint, Planning Your Future with Tom Begley, where clarity meets compassion. For decades, Tom has guided families through complex estate planning decisions with wisdom, care, and legal precision. I'm Kevin Rosenquist, and today we're going to talk about a big topic, the ABCs of guardianship. Tom, welcome back.
Good to be back.
So what exactly is meant by guardianship?
Guardianship is really what we call, court-imposed surrogate decision-making. And really, what does that mean? It means that somebody's appointed to step into the shoes of another and manage their personal, financial, and medical affairs. And there's two types of guardianships. There's the one that we develop in a will. So if we have minor children and we're concerned about their well-being, if we pass away when they're still under the age of 18, in New Jersey, you could write into your will the person you appoint to be in charge of the guardian. Now, in New Jersey, a guardian under a will does not have any financial authority, but they are the person that decides where somebody is going to, live, where they go to church or synagogue or other house of worship, what schools, what medical decisions, etc. A responsible will appoint somebody known as a trustee to handle the assets, which may or may not be the same person. The other type of guardianship is the guardianship for adult incapacitated individuals, and they fall into three categories. The first is somebody that was never competent to begin with, or able to make a living will or a power of attorney, and that would be somebody that was born with a developmental disability, and their cognitive ability is not high enough to execute independent estate planning documents. The second is someone that was competent, but say, unfortunately, due to an accident or some sort of malpractice medically, that they're rendered incapacitated during their 30s, 40s, etc. The main one that we've seen historically has been adult incapacitated persons who were like you and I, but they became in their 60s and 70s. And it was time for them to have somebody step in and handle their personal and financial affairs, but because they didn't execute a living will or a power of attorney when they had the ability to do so, the court has to appoint someone to act on their behalf, and that's the guardian. And that procedure is much different. Whereas with the guardian for the minors, that's a simple appointment of will, which will be honored by the surrogate's office. To get a guardianship for an adult incapacitated person, you have to go through a full-blown procedure.
Okay, so how does somebody go about establishing guardianship for any minor children that I would have?
Okay, well, for the minor, that's pretty easy. Make sure that you have a properly drafted and executed last will and testament. Because the last will and testament traditionally says two things. First, who's going to get your money where it needs to go when you're gone? That would be the executor, and a trustee if a trust is established. And the second is who's going to be the beneficiaries. But a last will and testament in New Jersey can also provide for the appointment of a guardian of a minor child. And so what happens is once, let's just say I'm single, my wife is predeceased me, and I pass on and I still have one minor child, believe it or not, what would happen is my executor would go to the circuit's court with my will and probate it, and on the spot, the person who's listed as the guardian would be granted letters of guardianship, as long as they sign two simple papers. So that's real easy. The more complex procedure is the one with the adults.
How does that unfold then, the one with the adults?
So it's a bit, to put it mildly. So in a nutshell, the first thing you have to do is have two people declared, two physicians, or in New Jersey, you can have one physician and one psychologist, execute a certification that says that the individual that requires a guardianship is indeed mentally incapacitated. And those two certifications are attached to what's known as a verified complaint, which basically sets forth, the purpose of the filing, which is to establish a guardianship on behalf of somebody who's an adult who's considered vulnerable because they're no longer able to take care of themselves. Mm-hmm. That should detail the relationship of the individual who's applying for the guardianship. Am I the son applying on behalf of my father, or the wife applying on behalf of my husband, etc. Then you've oftentimes will talk about how long or what led them to become incapacitated. For example, you'll say, John Jones, the alleged incapacitated person, was able to handle his personal and financial affairs until approximately 3 years ago when he began developing and experienced the effects of Alzheimer's and some other forms of senile dementia. So then you talk about how the incapacity came about. You cite the doctor's certifications, and then you state that you're ready, willing, and able to act as the guardian. And they also want you to detail in a separate form what's called a certification of assets. They want to know what does the individual own, what liabilities they have, and what income is coming in. And very importantly, you have to detail who are the interested parties. So, for example, my folks are still with us. I'm one of 5 siblings, and let's say I wanted to become the guardian on behalf of one of them. What would happen is, let's say I'll pick on my dad. So I want to become his guardian. I would have to make sure that I provide notice not only to my brothers and sisters because they have equal statutory priority to act, but I would also have to send a copy to my mother because she has a greater statutory priority to act as a wife. And you just have to list who those people are. And then you have to fill out some other forms certifying that you have no criminal or civil judgment history. It's a lot, as you can probably gather from what I'm saying. Once all those pleadings are filed with the court, usually within a week or two, depending on which county is looking at it, you'll get a document back called an order fixing a hearing date and appointing a court-appointed representative. And the order fixing a hearing date will basically say today's June 30th when we're talking, let's say 2 weeks out. We get an order on July 14th. They'll probably set a court date sometime in the middle of September, end of August maybe if you're lucky. And in between that time, you have to do 3 things. One is you have to serve the person who's going to be declared mentally incapacitated, because when you're establishing a guardianship, you're basically taking away that individual's legal rights to make decisions on behalf of himself or herself.
Right.
The other is the court appoints an attorney to make sure that everything is on the proverbial up and up, and also to advocate the wishes of the individual from whom you're seeking guardianship. And the third, as I indicated previously, you have to provide notice. And notice has to be provided first to the incapacitated person or alleged incapacitated person, and that has to be done by personal service. Everybody else is served both regular and certified mail. They get a copy of everything. Now, the court-appointed attorney is able to act on behalf of the individual who's going to have guardianship declared against them, because capacity is contextual. Some people certainly, as a result of a major stroke, are completely out of it, for lack of a better term. But you have people that have the middle or moderate stage of dementia. They can't make all decisions on their behalf, but they can certainly express preferences. For example, we've had cases where the person that required a guardianship was declared incapacitated by the court. We found that they certainly did not have the ability to make personal, medical, and financial affairs. However, the person was able to logically pick among their children who they wanted to serve in that capacity. So I've actually had a case where it was for a developmentally disabled daughter, but she was very high functioning. The mother had actually applied for the guardianship, but the father wound up being the better choice. And so, and that was a case where, although the mother did the right thing by starting the petition, the voice of the person who was incapacitated was heard.
Mm-hmm. Man, I see now why you said it was a lot more complicated than the other one. There's a lot of them.
You feel bad. I mean, like, for example, when someone has a developmental disability, most part they've never had the opportunity to execute a healthcare directive or financial power of attorney. As people get older, though, this is why I tell people many, many, many times, whether you're 18 or 98, or whether you've got $10 in the bank or 10 million in the bank, everyone should make sure they have a healthcare directive and a power of attorney. I know when we're younger, we think we're going to live forever, but there's a lot of times when we've had to deal with estates and estate planning issues regarding folks that are, way too young.
How do people go about choosing the guardian when we're talking about children? I mean, I feel like that's a tough thing to do. Do you kind of play a little therapist sometimes and sort of help coach them on how to do that?
Yeah, Kevin, that's one of the best questions you can ask, because sadly enough, a lot of times people make poor decisions because they'll go to who I refer to as John Doe attorney at law, who prepares the same estate plan person at the 10 o'clock they did for the 9 o'clock and the 12 o'clock. And he or she generally says, who do you want to have appointed? And people just give a name. And over the course of the past 25, 30 years, maybe the largest growing cause of action in the probate courts has been fiduciary abuse and neglect. And we usually find out is that there's no counseling done. And so when you talk about who should be appointed, first, as a trustee for a minor child, person should have two qualities: integrity and common sense. A lot of times we get people picking someone to act as a trustee because they're the oldest, they live nearby, they're a male versus a female, which of course nobody would hire somebody to be in charge of their money based on that. And as far as a guardian, somebody will say, well, they live close by, but I always ask about like issues regarding compatibility of the person. I mean, it just has to be somebody that's would find a warm, loving environment, not just somebody that's going to be able to provide a roof over their head.
Right.
It's the person when you go to bed at night, you think, well, if something happens and someone has to make decisions on behalf of my son or my daughter, who do I think is going to be able to see things the way that I would see them if I was still alive?
So once guardianship is established, like let's say I'm the guardian. What are my responsibilities at that point?
Okay, so if it's a guardian of the minor, I mean, your responsibility is to decide where they're going to live. Now, probably 95, 98% of the time, the minor child will live with the guardian. The reason I mentioned that they only have to make the decision is because sometimes people aren't sure which one of their brothers and sisters, for example, would be best suited because they're relatively young and they're mobile. And at times I've seen people appoint their parents knowing that they may be too old to actually have the kids come and live with them, but they will be the right person to make the decision as to which brother or sister of your clients is going to be best suited to take care of your children. So, but most of the time, the person who you live with and the person who is the guardian are one and the same. And then they're allowed to make medical decisions. They're the ones that deal with the schools. They literally do everything except for handle the money. It's time to go to, as I said, worship. People still do that occasionally. They're in charge of that sort of thing. Sports, they literally are the parent in the eyes of the law.
Okay. Are there alternatives to establishing a guardianship if for other situations where maybe you don't want that?
So, all right. So, well, for a minor, there's really no alternative because somebody has to have somebody take care of them, between the time they're born and the time they turn 18 years of age. At that point, the guardianship automatically terminates. But for the adult incapacitated person, yes, there are two alternatives. And in New Jersey and most states, we now recognize what's called the least restrictive alternative. So a couple times over the years, what happened was an individual had executed some healthcare directives and financial powers of attorney, but there was some concern about the management of the assets. So, well, actually, let me give you a better example. There was one where the person had some limited capacity. You didn't want them handling the books, but they could certainly make preferences expressed about medical decisions, or who they want to have take care of them. So in that particular case, the person was found to be competent enough to execute an advance directive, but not a power of attorney, and we established what's called a conservatorship. Now, that's a confusing term for some because in many states, conservatorship is actually the guardian of the property. But in New Jersey, a conservatorship is something you can establish while you're competent. And you have the same function for the most part as an agent under a power of attorney or a guardian, but it's with court supervision. It has, surety bond attached to it and protections of reporting that need to be filed by the conservator on behalf of the conservatee. You see those once in a blue moon. I will tell you there have been some times where a guardianship has been commenced, and we do find out that the person, although they shouldn't be making decisions on their own, still has the requisite capacity to execute a healthcare directive and power of attorney. I see this mostly in the cases that involve individuals who are developmentally disabled. people, for example, Down syndrome. I mean, there's a wide spectrum, or autism. There's a wide spectrum of abilities, limitations for individuals in those categories. The problem is many people tend to rubber stamp folks, and they think, well, they have Down syndrome. Oh, they've got autism. They automatically need a guardian. I'm happy to say that many times over the years, I've had parents come into the office, and after speaking with them and then speaking with their child for a while, I realized, on the one hand, they definitely need somebody to help them along to make those decisions. But they do have the ability to sign a document that says, I understand that when I sign this living will, mom's in charge of making my healthcare decisions. Or when I'm signing this power of attorney, dad can take care of the finances. So those are the least restrictive alternatives.
Okay. And if I'm excuse me, if I'm the guardianship is established, I'm the guardian of minor children, let's say, is it important for me to then get an estate plan in place that includes them as well?
Probably not, because generally the will under which you were appointed as the guardian names you, and it should name a backup. The only thing that, and also the same thing with a trustee. Now, I think that one thing you could attempt, and that's really, what ought to suffice. So, because quite frankly, you don't necessarily have the ability to unilaterally appoint someone. So let's say hypothetically somebody did name you as their guardian, and they've passed on, their kids are under their care, they're 13, 14 years old, and something happens to you, and you're obviously no way back as the guardian. Well, the person that prepared the will should have had the wherewithal to make sure there was a backup. But occasionally people don't do the right thing. And at that point, theoretically, it'd be nice if you could just say something in your will. But really what would wind up happening is the court would actually have to appoint someone. So somebody who's the next of kin or willing to be the guardian would have to make an application to the court saying that, that somebody passed on, you became the guardian, then something happened to you, you can't serve as guardian, and that, they're ready, willing, and able to serve. Fortunately, those issues with the minors don't happen too much.
Mm-hmm. Yeah. That's interesting. I was just curious, but that makes sense that it would then go back. And yeah, good advice for anybody listening. If you do have to establish a guardianship in any way, make sure you have a backup just in case, so that you get to decide where your kids are going for the long term. Absolutely. All right. Well, thanks for joining us on the Estate Blueprint. To learn more, to schedule a consultation with Tom Begley, visit Begley3law.com. That's the number 3. And if this episode helped clarify something for you, please like, subscribe, share it with a friend or family member who's ready to plan ahead. Tom, always great having you here. Thanks so much for the time.
Thanks for your time as well.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.